What regulatory powers should a strong disability accessibility law include? David Lepofsky, Chair, Accessibility for Ontarians with Disabilities Act Alliance. Delivered at the Osgoode Hall Law School, January 15th, 2014, as a Roy McMurtry Clinical Fellow.
Thank you very much. It's always great to come back to Osgoode, and it's especially delightful to have been honored by Osgoode as having been selected as the Roy McMurtry Clinical Fellow. I'll be here for 4 weeks giving lectures in various courses and available to students on an informal basis. 20 years ago this November, on the 29th of November, 1994, about 20 of us interested in disability, human rights, accessibility, and the like ended up through an odd chain of events in a room together at the Ontario Legislature at Queen's Park. When we went in the room, we each knew that we needed something new to be done to change our society, to make it one in which people with disabilities could fully participate. We knew we needed a new law, but we had no idea what that law would be. And we had no reasonable expectation that we'd ever win it. We went in that room just to talk about what to do. We came out of that room an hour and a half later having formed a new coalition. Weeks later, I became its co-chair and then its chair. And the next 20 years were history. A decade after that event, the Ontario Legislature unanimously passed the Accessibility for Ontarians with Disabilities Act 2005 with all party approval, unanimously. 4 years earlier, it had passed the Ontarians with Disabilities Act 2001, but two opposition parties, the Liberals and NDP, voted against it as being grossly inadequate. What I'd like to do today is not to talk to you about the political process of advocating for this kind of legislation, or the community organization strategy that brought people with disabilities from one end of this province to the other together to fight for it, nor do I propose to review the substance of the gains on accessibility we've won in the 8 years since the AODA 2005 was passed. They will be the subject of other lectures that I'll be giving while I'm here at Osgoode, and that we hope will be available for longer-term use through YouTube. What I'd like to do with you over the next few minutes that we have together is to talk very specifically about the regulatory strategy, the policy, the contents, the guts of the AODA, what we decided to seek, how we decided to map that out, how we figured out what to seek, what we got in 2005, and since then, what changes we've been able to get, to seek and to get in how that regime is implemented. So this is all about process. The substance is, of course, critically important. I'll be addressing that later. In the end, I will tell you, through the totality of the lectures I'll be giving, we've come a long way in terms of getting this legislation on the books as a community organizing strategy. And I believe we've come a significant distance since the enactment of the legislation at moving us forward, but we are way behind schedule at achieving the goal of full accessibility. Before I jump into how we crafted our proposals for this legislation, what the government did with those proposals, it's important for me to take just a moment or two to tell you about the social problem that this law aims to fix. Put simply, at least 17 or 18% of the population of Ontario, over 1.8 million Ontarians, right now have a physical or a mental or a sensory disability. That might be young folks or children born with a disability, older folks who acquire one through the aging process or through accident or injury. However, our numbers are not static. They're growing. The proportion of Ontario's public and Canada's public, indeed the world's population, that has a disability is growing because the greatest cause of disability is aging, and our population is disproportionately getting older. So we will have more and more, or a greater proportion of our society will have disabilities in the next 10 years than do right now. These folks, people with a physical or mental or a sensory disability, face barriers every day of their lives, whether they're trying to get a job or an education or use public transit or buy goods or services or take part in any other aspect of our society that other folks take for granted. Some of those barriers are physical, like steps to get into a bus or a building. Some of them are information barriers, like the lack of braille on some elevator buttons. Some of those barriers are communication barriers, the lack of communication supports like sign language interpretation for people with hearing loss in situations where they need it to be able to benefit from a good or a service or employment. Some of the barriers are bureaucratic, some are legal, some are attitudinal. So, in a nutshell, people with disabilities face too many barriers, and as a result, they're excluded disproportionately from so much of our society and what it has to offer, and they end up disproportionately overrepresented among the poor and the welfare dependent, and underrepresented among the educated and the employed. That's the problem. The barriers we face ultimately hurt everybody because everybody either has a disability now or will get one eventually. We are the minority of everyone because everyone has a disability, has someone dear to them who has a disability or will get one. Now, it happens that these barriers are all illegal. They're all illegal. They violate, in the case of the public or private sector, the Human Rights Code's guarantees of non-discrimination and access to employment, housing, goods and services, and facilities. And in the case of government, the guarantee of equality to people with disabilities in Section 15 of the Charter of Rights and Freedoms. The problem that led 20 people to end up in that room at Queen's Park in November 29th, 1994, was even though they're pretty much all illegal, they too often, far too often, the vast majority of the time, those barriers remain. And as quickly as old barriers might be torn down, new ones are popping up. Why is that? There are two reasons. This underpins everything I'll be talking to you about. The first is that those laws, the Human Rights Code and the Charter, while wonderfully interpreted by our courts for the most part, after some bumpy starts, are way too vague. They don't tell an organization what to do. If you walked up to a restaurant owner and said, you don't have a Braille menu here, so you are violating the Human Rights Code, they'd look at you probably like you were crazy. They wouldn't have the first idea that they're violating the Human Rights Code. Same with many, if not most, of the barriers. And the second problem, so the first problem is that organizations, for the most part, don't know what they have to do or don't know they're in breach of the law. The Charter and the Human Rights Code speak in very broad terms. Don't discriminate, do accommodate. But they don't tell people the specifics of what they've got to do and when they got to do them by. The second problem is whether or not an organization knows they're violating the law. The fact is, if you want to enforce your rights, you've got to bring individual cases or complaints, either under the Human Rights Code or under the Charter, to fight barriers one at a time. Most people with disabilities, poor, unemployed, disproportionately underrepresented by the legal profession, are not likely to be able to avail themselves of that process. I've used it myself. I had to bring not one but two cases to get under the Human Rights Code to force the TTC to audibly announce all bus and subway stops. It's not a fun process. Most won't devote themselves to that, undertaking that hardship. So that's the problem. This led 20 people to come into a room, say we need a new law to fix it. Initially, the name we wanted for that law was the Ontarians with Disabilities Act. The name changed over time for reasons that don't matter for purposes of our present discussion. But when we entered that room, we didn't have the slightest idea what we wanted the law to contain or to do. We didn't know about any of we hadn't figured out any of the details. That came later. We made a strategic decision early on when we formed our coalition which I ended up starting out as co-chair, and as I said, to this day, end up in a chair role. First, the original coalition, the Ontarians with Disabilities Act Committee, up to 2005, and then its successor, the Accessibility for Ontarians with Disabilities Act Alliance, from 2000, formed that year, and I became its chair in 2009 to the present. But in any event, we decided early on that we weren't going to get involved in the details of what the legislation would contain until we had a government at the table who really wanted to talk business with us. Let me jump forward to 2003. In 2003, the Ontario Liberal Party, by the way, we're nonpartisan, we'll work with anyone, but the Ontario Liberal Party was elected on an election commitment to us to enact a Disabilities Act that would cover disability barriers in the public and private sector, that would be effectively enforced, and that would involve key principles that we'd put forward. That was when we realized that we now have to be ready in a serious way to get into detail. We'd done some policy development up till then, but 2003 was when we especially had to turn our attention to the question of how this legislation, or what regime for compliance and enforcement we would use in this legislation. What I'd like to do now is to tell you about the process we used for coming up with our ideas, what we got from the government, and the specific, or some of the specific changes that we've had made to it since the law was passed in 2005 in order to correct problems that we've identified. So, 2003 rolls around. We knew what the goal of our legislation was: removing and preventing these barriers, achieving a fully accessible society. We ultimately knew that we wanted to not to change the rights guaranteed in the Charter or the Human Rights Code to people with disabilities, but simply to come up with a way to have them effectively implemented in the public and private sectors without having to litigate barriers one at a time. So we had to figure out how to do this. I had a problem, which is, as the chair of the coalition, I didn't have all the answers. I happened to be part-time faculty at U of T, teaching a course on freedom of expression. So I approached some faculty members there, including a fellow named Lorne Sossin and a couple of other faculty members, and we pulled together essentially a team, I called it the Brains Trust, to come up with ideas. We worked together over weeks, and these folks were both dedicated and generous with their time, and extremely creative. As a result, we developed a discussion paper, which we put up on our website and emailed out in June of 2004. It tackled a series of issues. The issues we identified included these. First, what exact model for compliance are we going to use? Are we going to require organizations to develop accessibility plans and then just police the quality of those plans? Or are we going to develop a system of accessibility standards? Or are we going to use both? Well, we had some experience to draw on. Because in 2001, a couple of years before, when the Conservative Party was in power in Ontario and Mike Harris was the Premier, they had committed to pass a Disabilities Act, but were very reluctant to include any teeth in it, They passed a law in 2001, a very weak one, called the Ontarians with Disabilities Act 2001. It only applied to the public sector. It did not require the private sector to do anything. And in the public sector, all it required organizations to do, whether government ministries, universities, colleges, hospitals, public transit authorities, and the like, all it required them to do was to annually develop and make public an accessibility plan of the barriers they were prepared to address. It didn't require the plans to be any good, and it didn't require these organizations to ever implement their plans. They just had to make a plan, whatever it was, and make it public. We learned from that experience that planning alone wasn't enough. And indeed, organizations that were bound to develop these plans agreed in a number of cases They didn't want to each have to reinvent the accessibility wheel, organization by organization. And interestingly, we ended up having a common view from our coalition, then called the Ontarians with Disabilities Act Committee, and some of the obligated sectors, that the way to solve this was to set some common standards that would tell organizations exactly what they've got to do and when they got to do it by in order to achieve accessibility. Now, we could have had a law that both set a requirement for accessibility planning and required accessibility standards. In fact, that's what we ended up asking for. But we mapped out both options in our discussion paper. In coming up with these ideas, like, where do you get these kind of ideas from? Well, there isn't sort of an off-the-shelf, no other province had a Disabilities Act that we could look to, and other legislation around the world, we did look to it, but other legislation around the world and often had parts of law of legislation we already had. There was a law called the Americans with Disabilities Act, passed in 1990. It's got a lot of good things in it. It's got some limitations. It included, and we stole the name from that, Ontarians with Disabilities Act came from Americans with Disabilities Act. But that law, a key part of it is just the right to sue for discrimination based on disability. Well, we've had that since 1982 in Ontario. But we found that it did include some useful features, especially the requirement or the power of the federal government to develop and implement accessibility standards in different sectors to tell organizations what they got to do. So that was helpful, but it only got you a certain distance. The Americans with Disabilities Act there was some controversy about it, how effective it is, did it really work, and so on. So when I sat down with then Professor Sossin and our Brains Trust, I said, well, does anybody sort of study comparative regulatory regimes in administrative law to find out what works? And the answer was, no, we don't really do that. We have different people who study principles of judicial review or look at specific areas like environmental law or securities regulation or whatever. But we couldn't find anyone who had been looking across the board at different regulatory sectors or regulatory regimes to tell us which ones work and which ones work better than others. So that wasn't going to be a solution. And if you talk to individual private sector or even public sector administrative lawyers, they litigate individual cases under administrative law principles. And they don't look at the big picture. They tend to, I don't mean that as a criticism, they focus on an individual dispute under a law they've already got to deal with, whether it's a labor law or whatever it may be. So they weren't really in a position to help us too much either. And human rights scholars spent most of their time studying what the Human Rights Code says and how it should be interpreted, or analyzing the outcomes of individual cases. And we didn't find from them a lot of guidance on how to design a new system. So what our Brains Trust came up with as an idea is let's just try to figure out what regulatory systems or laws deal with a similar problem. And the two that then Professor Sossin, before he got elevated to his current lofty height as dean, they came up with this idea of two regimes to look at. One was environmental laws, and the other was occupational health and safety laws. And the reason that those two came up is because they're not identical to the issue we're talking about here, but they cut across a lot of businesses, a lot of organizations, public and private sector, and between the two of them, they deal with relatively complicated issues that affect real people. It may be complicated to deal with different kinds of pollutions, but toxins hurt real people. And occupational health and safety, you can get into all sorts of complicated issues of what kind of machinery is being used and what kind of safety measures are in place and all that stuff. But ultimately, you're trying to ensure that workers don't get hurt. So we had both real people problems and complex business settings. And it was from those two regimes that we cobbled together our ideas. And we put out an options paper, a discussion paper, in the summer of 2004. And while time doesn't permit me to get into this here, I'll just tell you in a nutshell. I continue constantly to be impressed and delighted at how many disability community organizations, how many individuals with disabilities and individuals without disabilities will review this stuff that lawyers would think of as being dry, boring, and technical, would dig into it, come up with interesting ideas based on it, and make really good recommendations. And they did, drawing on this discussion paper when it came time to get submissions to the Ontario government. So we worked together, came up with this discussion paper, and circulated it. In terms, and two of the main ideas that we were proposing, there are others, but the two of the main ideas was the idea of developing and implementing accessibility standards and having a regime for accessibility planning. Standards address the need by saying, and organizations don't know what they have to do or when they got to do it by, a standard will tell them. Organizations often, if you point out a barrier in an organization, typically their answer is, oh, we never thought of that. The restaurant that doesn't have Braille menus is because they sat down and said, let's make sure we never have Braille menus. And we want to make sure blind people can't read our menu. They never thought of it before. So if the answer was, if the common experience was, we didn't think of it, accessibility planning is designed to require them to think about it. That's how we crafted sort of the guts of our proposal. Now, when it came time for the government to develop its law, it took our discussion paper, got input from the public, and it came up with proposals which it introduced in a bill in the Ontario Legislature, a proposed Accessibility for Ontarians with Disabilities Act. They gave it a new name because the Conservatives passed the Ontarians with Disabilities Act, and so they wanted a new name, so they called it the Accessibility for Ontarians with Disabilities Act. That's why we have these two different laws by two different names. And then they held public hearings where we, again, could have input. And we used the guts of the proposals we developed in that discussion paper in the summer to inform the proposals that we came forward with for amending that legislation, which ultimately passed in May of 2005. So what did we get? What came out in the law? What is the essence of this legislative regime? Well, it has a number of key components. I summarize. Number one, the goal of the legislation stated in the law is that Ontario is to become fully accessible to people with disabilities by or before 2025. I want to tell you, the idea of a deadline was not our idea. Love to claim credit, say, wasn't that brilliant of us? We never thought of it. It was actually an idea that came from within the government, and it was a superb idea. It's had a dramatic impact since, because the moment this law passed, we said the clock started ticking, and our constant refrain is, are we on schedule? Are we on schedule for full accessibility by 2025? That was their idea. Just a deadline alone. We won't see it in our discussion paper, and it was a great idea. Next thing that they said was that the government has essentially an obligation to lead Ontario to that goal, and the way it will do so is by developing, enacting, and enforcing accessibility standards. What is an accessibility standard? It's a regulation that will speak to either one sector of the economy, transportation or something like that, or one swath of human activity that cuts across all organizations, like employment. Tell them what barriers to remove, when they have to remove them by, and so on. The law provided that that standards didn't have to be one size fits all. It wasn't simply saying everybody must accomplish X by this date. It could take into account whether an organization is public sector or private sector, whether it's large or small, and it could set different requirements and different timelines. We agreed with all of this. How were the standards to be developed? This is a really important thing. Usually regulations are just things that public servants work on, develop, they go to cabinet, they're approved, and that's that. We, in our discussions with the government, and arising from the excellent assistance that we got from our Brains Trust at leading up to this, we said that these should not just be invented at Queen's Park. We need a system in place for how these standards are made. Here's how the system goes. First, the government has a mandate to decide which standards will be developed. And it has a free hand to do this, but it has an obligation in the legislation to make all the standards needed to get to the law's goal, the statute's goal. And that goal is full accessibility by 2025. So we could turn to the government at any time and say, have you made all the standards needed to get us to that goal? Or in turn, if every organization complies with all the standards you've made, will we achieve that goal of full accessibility by 2025? That's in the law. It's rare. Typically, legislation says government may make regulations. Here it said it must. And it put a test forward. Well, how are the standards going to be made? Well, in our discussions with government, we said that there are two sources of wisdom the government should draw on. People who know the most about the needs of people with disabilities, and that's people with disabilities, and people who know the most about how to run an organization, and that's people who run organizations. So we said, why don't you set up a committee for each standard? They call it a Standards Development Committee. And on it, there'll be representatives from the obligated sectors, from the public sector, from business, and so on, and from people with disabilities. They'll put their heads together, put together proposals, submit them to government, and the government will can then decide whether it wants to enact the proposals in whole or in part. Once enacted, it's a law. And under this regime, the Standards Development Committees, after 5 years, are to review the standard that was first made so that we can see if changes need to be made to make sure we get to that goal of full accessibility by 2025. That was the basic regime. Well, next comes an important policy question. How are you going to make sure the system works? You don't want to end up on Christmas Eve 2024 and find out, oh shucks, we're nowhere near there. So there are several accountability mechanisms built into the law. First, when standards development committees meet, they have to keep minutes and they have to make the minutes public so we can know what's going on there. We wanted them to actually meet in public. The government wouldn't agree with that. So the secondary, their fallback was to have these minutes. Second, when a standards development committee makes a recommendation, it makes first a preliminary recommendation. That's made public. We give input. They then review our input. They make a final recommendation. That's made public. And before the government can enact a regulation, it's got to make a draft regulation public as well. And we can give input on that. At one level, you may say, man, that's a lot of giving input. But through this process, we can see what's being considered, and we can give input, as can the obligated sectors. And if the government's winnowing or whittling things down, we can track that. We can see how much they're prepared to do compared to how much they were urged to do by the very people they appointed to develop these standards. The next accountability mechanism that's built in is that the minister responsible for this legislation has to make an annual report to the legislature on how things are going. By the way, we didn't hold our breath on that one because they tend to write these self-serving, aren't we doing a wonderful job statements, which is basically what's happened every year. But there was one other accountability mechanism that was built into this law, and it's a really important one. There is a requirement in this law that every few years, first after 3 years after the law was enacted, and then every 4 years after that, the government has to appoint an independent person to review how the law is working and make recommendations, essentially to see if we're on track and on schedule. The first independent review took place in 2010, and the second one, as Lorne mentioned, is going on right now under the auspices of Dean Mayo Moran of the U of T Faculty of Law. So that was the basic framework of the law. How's it going to be enforced? Well, if you go back to our discussion paper, we laid out a whole range of options by the Human Rights Commission or by the government or by an independent agency. We ended up urging that the government appoint an independent arm's-length enforcement agency with powers to audit, inspect, issue compliance orders, and so on, and then have an independent tribunal that the complaints can be appealed to. The government agreed to incorporate in the law powers of compliance orders, inspections, audits, and monetary penalties, including potentially very steep ones, but did not make this independent. Rather, it's managed by a body called the Accessibility Directorate of Ontario, statutorily created, but part of a government ministry. Accountable to a cabinet minister. So that's the regime. Well, 2005, passed unanimously. We all celebrate. How did it go? Let me break this into different chunks of time. 2005 to 2007. It starts out actually very well. The government quickly decided that there were 5 accessibility standards that need to be made first. The 5 they picked were very good choices. Customer service, transportation, employment, the built environment, and information and communications. Top grades for their choice. And they appointed standards development committees to do each and got them up and running relatively quickly, given that this was a very new initiative. By the way, the government acted very quickly in developing this law. The government took power in October of 2003. They had a bill introduced by October of 2004, and it got third reading in May of 2005 after province-wide televised public hearings. That's actually quite prompt action by a government, much less one that's just newly taken power. After that, we came to realize fairly quickly from the experience of the first 2 standards development committees that hit the ground running, the one dealing with customer service and the one dealing with transportation, that there were a number of significant problems happening from a disability perspective at the standards development table. This led us to go to the 3 political parties in the 2007 election and actually ask them to make election commitments, not for legislative amendments, but for very specific actions on how they implement these laws. Interestingly, all 3 parties, while they don't agree on much, agreed on many of our proposals. What were the problems? What were our proposals? And what did we get? First, we found out early on that the government appointed, when it selected who it would appoint to these standards development committees, people with disabilities were always the minority. That the number of public and private sector representatives outnumbered them. So on any vote, if there was a debate about how far the standard would go or should go, the disability community always lost. So we urged that 50% of the standards development committees should each always be made up of people with disabilities. And the government agreed. And by the way, it did make a significant difference looking at what happened afterwards. Second, the way these standards development committees were working, at one side of the table you had representatives of public and private sector organizations who often had access to a lot of resources. Government agencies, and the Transportation Standards Development Committee, in came all these public transit authorities, paid for by you and me, the fare box, or by the taxpayer, who could hire lawyers and policy people and so on. And the disability sector was not only outnumbered, they were outgunned in terms of access to expertise. And they were often volunteers. They didn't have access to the supports they needed. We asked the government in 2007 to provide support to the disability sector so they could at least be in a position to have a level playing field when they debate these things in terms of research and support. The Liberal Party, for their part, promised to provide 1 staff person to provide research support, and they did. Not sure that was enough, but at least it was a start. The third thing that we found out that was wrong, this is all learning by doing, by the way. Like, you can't, we didn't have a playbook to work from. We were just figuring this out as we were going along. And to the government's credit, so were they. But the third problem that we found out with these standards development committees is that they weren't consulting with the community, other than where they statutorily had to. And we thought that there might be times there was a dispute or an issue coming up that was worth them inviting people in. They had a statutory authority to, but let me give you a classic example. I was in the middle of litigation against the Toronto Transit Commission personally to force them to announce subway stops and later bus stops. And I had found out from some members of the Transportation Standards Development Committee that they were having a real debate. The transit authorities didn't want to require their drivers to call route stops. That may sound a little crazy. It was. But they were putting up a fight there, just like TTC was putting up a huge legal fight at the Human Rights Tribunal against me. So I wrote the committee and asked, can I come to a meeting and at least pitch to you what our concerns are? And they refused. I got in writing that they would not allow me to come to a meeting personally to a meeting of the Transportation Standards Development Committee as a blind person to explain why it's important for us to have drivers to call route stops. This seemed like something was really seriously broken in their deliberative processes. And remember, this is taking place at the point where the disability sector was outnumbered, so they'd lose every vote where there's a contest. The other major problem that we found out took place was that the way these committees were working, they were ultimately voting on proposals all or nothing. So they would discuss a bunch of proposals, but then eventually the question would come up, basically, here's our proposal for an entire standard, do you vote for it or you vote against it? And this put the disability sector in a real bind, because they might think the proposal is absolutely weak and appalling. But if they vote against it and it's defeated, then nothing goes out for public comment, and the process dies. So in the end, they end up having to vote for it just so it moves forward, after which the proposal is released publicly with the statement, everybody voted for it. So it makes it sound like they were unanimous in supporting a proposal that the disability sector actually thought was way too weak. The transportation example is a good one. When it came to calling route stops, they ended up in their initial proposal recommending that, yes, public authority, transit authority should be required to call all route stops, but they should be given 18 years to start doing it. I can't make this stuff up. So the disability sector reps came to us and said, this is not right. So we went to the government and we said, they should be able, why don't you change the way you do this? Why don't they vote clause by clause like you do in the legislature? And if people oppose something, let them give their reasons. So when a recommendation comes out from the committee to the government, let's make public both the recommendation and if people vote against it, what the vote against it was and what their reasons were. And this works for both sides. If something comes out that some business representatives think was too aggressive or the timelines were too onerous, let them vote against it and say, it passed 12-5, and the 5 could give their reasons why they thought. So the government and we, the public, could read the results and decide what to recommend the government actually do with their proposals. So the good news is all these, the government committed to pretty much all of that and implemented, I would say, most of it. Ironically, after the 2007 election, the chair of the Transportation Standards Development Committee, on behalf of what was still a majority of non-disability representatives, wrote the cabinet minister asking them to break their election promise to us, which after an election, usually politicians don't say, yes, I'll break my election promise. And they carried on under the new regime. So that was a huge and an interesting process in learning how to fix it. Troubling, though, was the fact that the fix had to come from us during an election, going to the premier and the 2 leaders of the opposition. When we made these proposals within government, they didn't, at lower levels, they didn't go anywhere. So that's 2007. Let me take you from 2007 to 2010. What happened next? Well, then these standards development committees toiled away, worked very hard, came up with a series of proposals, actually between then and 2011, 2010, that's correct, released various proposals, interim proposals, got input from the community, then came back, came out with final proposals, and the government had them on their plate to develop standards. The government enacted one standard in 2007, the first customer service. In 2011, in June, it enacted another 3 dealing with employment, information communication, and transportation, all in one comprehensive or integrated regulation. In the end of 2012, they enacted part of the built environment proposals, those that deal with public spaces outside, like parking spots, sidewalks, recreational paths, and a few other things. Things that deal with inside the building, they've just passed a couple of weeks ago some amendments to the building code, but nothing under nothing in the form of an actual standard under the Accessibility for Ontarians with Disabilities Act. But for your purposes, let's not deal with the substance of what they passed, but what more did we learn and what more has developed in terms of how this regulatory regime works. Well, the next critical date is 2009 to 2010. Because while all this work is going on, the magic date arose in June of 2009, that was 4 years after the Disabilities Act was passed, when the government had to appoint its first independent review. And that independent reviewer, who was appointed, was a gentleman named Charles Beer, a former provincial cabinet minister from the 80s, and widely recognized from all perspectives as a wise, thoughtful, attentive, and fair individual. He went out and held consultations talking to the business community, the disability community, government, and so on. The message that he got from both the disability sector and the obligated sectors was that while the government had made a good effort at making the standards development process work, there were some real problems. There were 4 or 5 different committees working on different problems, and there was no coordination between any of them. A lot of them didn't quite understand what it was they were supposed to be doing. Even after the changes in the process that we won in the 2007 election, a number of them found that the process was convoluted. They were also big committees, and it was hard to develop consensus and so on. We, in turn, went to the Beer, Charles Beer Independent Review and said, in addition, we're concerned that this whole process is not even trying to develop accessibility standards that will live up to the requirements of the Human Rights Code or the Charter of Rights. Now, at that point, Charles Beer only had one standard that had been passed to look at, the 2007 Customer Service Accessibility Standard. Remember, he's doing this in 2009, and the other standards weren't enacted until 2 years later. So he was dealing with process, the subject we are dealing with here. He also found that throughout all of this, there was very little understanding about the Disabilities Act or awareness of it among the obligated sectors, business and so on. And he ended up rendering a report that was tabled, the Charles Beer report. It's available, by the way, on our website, aodalliance.org, as well as our analysis of it. He rendered a report to the government in February of 2010, which the government studied and then made public on May 31st, 2010. He basically reached the following conclusion. He said the government means well, but they dropped the ball. He said that really the government celebrated the passage of this law in 2005, and they went back to business as usual, and he said there is a real need for the government to revitalize the implementation of this law and to show new leadership on it. He echoed the concerns that people had about how the standards were being developed and recommended some significant changes. First, he said the government should appoint one minister responsible for all accessibility issues. And the lead public servant on this file in the Ontario government was an assistant deputy minister. They should be made a deputy. In other words, the profile of this within the public service should be ratcheted up. He also proposed that the standards should be harmonized. They shouldn't be dealt with all in little silos. They should be done in a coordinated, so business can all know, and the public sector, broader public sector can know what they got to do with timelines that are coordinated among themselves rather than scattergun, which actually makes a good load of sense. But he also said that the process of how these standards are being developed should be consolidated. Instead of having 5 different standards development committees, he was impressed by the United States model under the Americans with Disabilities Act, where they have a central access board to develop a number of proposals. He said the province should amend the Disabilities Act to create a single body, arm's length from the government, with its own staff that will develop accessibility standard proposals. Won't enact them, but it'll develop them. We supported pretty much everything he recommended except a couple things that I haven't covered and that don't matter and that are secondary. And we didn't hear anyone in the broader public discussion of this issue from any side who opposed what he proposed. So the next question is, what's the government done about it? Well, they took their time. I will tell you that they, to this day, have not appointed a single minister responsible for all accessibility issues. And we still have a problem in the Ontario government, the largest employer, the largest service provider, the organization that describes itself as being the wanting to lead by example in how to do accessibility. We still have accessibility dealt with in silos, uncoordinated across the Ontario government. There are some efforts to deal with it. There's been some progress, but there's some unbelievable problems within the public sector that could have been easily fixed. They have not elevated the assistant deputy minister to be a deputy minister. Essentially, business has been as usual, subject to one change that just took place a year ago, and which is not one that he recommended, but one that we are delighted with. They moved the Accessibility Directorate from the Ministry of Communication, Community and Social Services, that's the Welfare Ministry, to the Ministry of Economic Development and Trade and Employment. We were happy the government decided that accessibility would be seen as an issue of economic development, not as an issue of social assistance. They haven't done very much of a good job of integrating it in their economic development strategy, but at least they took this step that was symbolic. What have they done with his proposal for how to reform the process for developing accessibility standards? Well, the government has done what it could within the confines of the statute as drafted. We have made it clear publicly that we did not want the Disabilities Act reopened. We don't want amendments to it at all. We don't want any fiddling with it. We want it to remain sacrosanct. So the government looked at the Disabilities Act and said, well, how can we do what Charles Beer recommended as much as possible without altering the statute? So what they did is they decided that there was a body that already exists under the statute that had very little major role, and they made it the new standards development body. The body is called, it's got one of these government names, the Accessibility Standards Advisory Council. It was created under the Disabilities Act, or extended under the Disabilities Act in 2005, basically as a body that would give the minister general advice on accessibility. I will tell you that governments often have these advisory bodies to deal with various issues of social concern. It's my own lay, uninformed, and perhaps speculative view that most of them don't get much real opportunity to have much impact, no matter how good the people are who are on them. And there were really good people on this body, but up until this past year, that council, I don't think was used to its full advantage. And I'm not aware of, and we're not aware of it having a substantial impact on the efforts of the government to achieve accessibility. So what the government says, well, we got this council anyway. Why don't we next time we're going to make any access standards, let's appoint them to be the Standards Development Committee. It'll be one body, it'll be all under one roof, it'll be harmonized, it'll be together, and it'll be ongoing, it'll be a consistent process. We said, great. The good news is that a year ago the government announced that they were going to do this, but they took fully 5 months to appoint anybody, or maybe even 6 months to appoint anybody other than the chair. And they haven't given them any new standards to develop. So they've got the body ready to go. They haven't given them the work. And in fact, the only thing that this council has on its radar right now is that the 2007 Customer Service Accessibility Standard came up for its 5-year review last year, and they've got to do that review. We've not seen any sort of significant public action on it, though we've been told it's on their agenda. They're good people on that council, but we're very critical of the government for not actually giving them the work they need to do once they were given the mandate to do that work. So let me just spend a couple of minutes. So that's where we are now, and now we have let me spend the last couple of minutes just taking you through a bit of where are we at now in this overall regime. Not which barriers are being fixed or which ones need to be fixed. That's hugely important. I'll be dealing with that in other lectures. But in terms of the perspective you folks are taking, which is looking at different regulatory regimes for solving social problems. Number one, we have an independent review, and this is going to be right on that reviewer's plate, Mayo Moran. The independent review is, in a sense, illustrative of the kind of problems we've been facing as of late. We believe we're way behind schedule. We are not going to achieve full accessibility by 2025 or anywhere near then. The government was actually statutorily obliged to appoint the independent review by May 31st of last year, and they didn't. Actually ran an op-ed in the Toronto Star online about the fact that they were actually in breach of their own law. And they remained in breach of their own law. We ran a daily count on Twitter for over 100 days. The government itself not complying with its own timelines is hardly setting a good example for how business and other public sector organizations should do in obeying timelines they're supposed to comply with under the Disabilities Act. That's a huge issue. Second, just to give you the sort of the current situation, what about enforcement of this law? What about enforcement of this law? Remember, I told you that in 2005, the government included powers of inspection, audit, compliance orders, and so on, but kept them in-house within the government, not assigning them to an independent agency. Well, starting in 2010, there was something to enforce, the customer service standard relative to the public sector. And starting last year, the start of 2013, the customer service standard obligations were enforceable as against the private sector. Well, the government did some work with the broader public sector, but we chased them for all of last year to find out what they were doing to enforce in the private sector. And we were able to do this focusing on one major question. See, under the Disabilities Act, customer service standard, any organization with 20 or more employees that provides goods or services to the public had to file by the start of 2013 with the government, e-file, a compliance report just saying, are you in compliance? So we wrote the government in the end of January last year saying, how many filed, how many didn't, and what are you doing about it? They didn't answer. They didn't answer. They kept not answering. We kept raising it, and they kept not answering. So finally, in August of last year, I filed a Freedom of Information request. The government told me eventually that I'd have to pay $2,300 and some odd to get them to answer that request. I knew that it would be, or I believe that you'd only have to push a button to get the information off the computer of how many were in compliance or not. And as for producing their plans for enforcement, if they needed to spend $2,300 on public servants to find that plan, it mustn't be on the top of their desk. Eventually, questions in the legislature and an editorial slamming the government and the Toronto Star led them to hand over the documents we were seeking. What did we find out? This was reported in the media last fall. Of those private sector organizations with 20 or more employees in Ontario, fully 70% had still not filed an accessibility compliance report by November of 2013, over 10 months after the legal deadline for doing so, after having been given 5 full years to prepare for compliance with what is a relatively simple regulation to meet. We also found out through that Freedom of Information request that the government had conducted no inspections of any private sector organizations, no audits, they'd issued no compliance orders, and had not imposed one dime of monetary penalties.
Apart from that, they were doing.
Other than that, they're doing a great job.
We're just about maybe 5 minutes before the break.
The break, yeah, absolutely. So we needless to say, enforcement is a huge issue. I can't leave this topic, however, by leaving you to with the image of this being solely about regulations and about compliance and enforcement. There are a number of other fronts to complete the picture, and I'm going to just list them quickly, and then we wrap up. To achieve the goal of full accessibility, while the standards development, enactment, enforcement regime is critical, we believe throughout that there are a number of other parallel strategies that need to be pursued. Let me list them and tell you what's going on really quickly. And they're really interesting. Number one, government money talks. Government spends a fortune every year on infrastructure, on capital, and on procuring goods and services. We've called on the government to comprehensively require that no public money can be used to create barriers or perpetuate or exacerbate barriers. We've gotten some progress, but that lever of power has largely been substantially unutilized or underutilized. Number two, we believed from day one that it was important for the government to review all its own legislation and regulations to make sure that they don't themselves either impose barriers or authorize the creation of barriers. And in 2007, Premier Dalton McGuinty promised that such a review would be done, said it was the next order of business. The government didn't even start doing it for at least 3 or 3.5 years. It's still underway now. Number 3, there are some areas where individual or some environments where this regulatory regime just sort of won't fit, but where action is needed. Courts are a good example. You can't develop a standard for telling judges how to deal with accessibility in the courtroom. It's just not going to, it doesn't work in the judicial environment. In 2005, our then Chief Justice Roy McMurtry, after whom the fellowship I've had the honor of having was named, called on the judiciary to do their part to achieve accessibility. He appointed a committee of the bench, the bar, and the government to develop a roadmap to make the courts fully accessible. That report was submitted. I had the privilege of serving on the committee that developed it under the leadership of Ontario Court of Appeal Justice Karen Weiler. The Weiler Committee report, available on the Ontario Court of Appeal website, was tabled in 2007, and a permanent joint committee of the bench, bar, and government in Ontario, called the Ontario Courts Accessibility Committee, has been working since then, I'm a member of that committee as well, on working on strategies to address barriers in our court system. We also need a comprehensive strategy for education. And we really want to target 2 groups. The natural thing you think of is educating businesses and all. Of course, you got to do that. But we've called on the government to develop a strategy for ensuring that school kids get education on accessibility, so the next generation will know better. And also for professionals like architects, doctors, nurses, and you bet, lawyers, who provide services to individuals to know about the need to provide barrier-free services as well. At the very least, somebody gets a license to be an architect should know how to design an accessible building. That ought to be pretty rudimentary. So far, we have gotten far too little action on that front. And finally, we believe that voters with disabilities need to have full and equal access to the ballot if our political clout is to be heard and if governments are to be truly held accountable on this issue. We estimate there's over 1 million voters with disabilities, but too often they face barriers in voting, either getting to the polling station or, in the case of people who are blind or dyslexic, independently marking your ballot. One solution we've been urging is telephone and internet voting, not only for us, but for everyone. So far, Elections Ontario has been extremely slow and unreceptive to this proposal. Let me conclude by saying that the 20 people who got together in that room back 20 years ago this November, who started the movement that became the Cross-Disability Ontarians with Disabilities Act Committee and later the Accessibility for Ontarians with Disabilities Act Alliance. Our community started out not knowing about anything that I've just spent the past hour talking to you about, including me. None of us did. We've learned by doing. We've learned by having wonderful people to advise us along the way, and we will continue to learn by doing. If you want to learn more about this, I encourage you to consider a couple of options. One is we provide regular email updates. Just send a request to sign up to aodafeedback@gmail.com or follow us on Twitter at AODA Alliance. Either way, you can find out a lot about this. We are a news source about accessibility here and around the world. Anyway, I welcome the chance to take your questions, and I thank you so much for the opportunity to speak to you this afternoon.